Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner of WR Immigration in San Diego, and I am joined by Miki Matrician, who's our co-managing partner of WR Immigration's Boston office. So good to see you today, Miki.
Hi, Kimberley.
In response to one of our benchmarking surveys, many corporate immigration professionals noted that one of their concerns is making sure that their employees do not find themselves stuck abroad when they travel. So it's a timely topic. People are getting ready and gearing up for summer travel. So it is good for both HR, global mobility, and the foreign national employees to be in the know before they depart the US to see their families or to go on vacation. While it's very easy to leave the US typically, everyone needs to make sure that they know how to get back into the US before they leave, as well as make sure that they have all the necessary documentation to make for a smooth and hopefully non-eventful reemergence into the United States. So, Miki, let's start with our first question of the day, which is, since we are still in CAP filing season, we have another 6 weeks to go. Let's first address people with H-1Bs that are still pending with USCIS, and these are CAP H-1B petitions. If someone is on F1 optional practical training, they were selected in the lottery, and then a change of status H-1B petition is pending with USCIS, what would you say about their travel plans?
Yeah, so it's really important to discuss travel plans and strategies with HR as well as with foreign national employees. And when a change of status is filed with USCIS, leaving the US would be an abandonment of the change of status request. So, what that means is that if an individual travels while the H1 petition is pending, additional action would have to be taken at a later date in order to activate that H1B status or for the employee to step into H1B status. And so that could mean that another filing of a petition would be necessary to request that change of status, or that employee might have to apply for an H1B visa stamp at a U.S. consulate abroad before they can come back into the U.S. to begin working to step into H1 status.
Okay, so it creates an extra step, so to speak, for everybody.
Exactly.
So what about this particular situation where the employee is an F1 OPT with a CAP H-1B petition that is no longer pending, but instead has now been approved?
Yeah. So when we talk about international travel situations in that context with HR, we let them know that, for the F1 student, they could generally travel abroad and seek readmission to the US during CAP Gap only if the student's H-1B petition and request for change of status has been approved. So not pending, but approved. The F1 worker seeks readmission before their H-1B employment starts. So normally at the beginning of the fiscal year on October 1st. And there's no other issues, meaning the F1 worker is otherwise admissible. And so even if they meet all of those requirements, though, it's important to know that ultimately it's up to the U.S. Customs and Border Protection Officer that inspects the F1 worker that comes back into the United States. So, it's never guaranteed that there would be no issues with readmission. There's also, an important point to be made that the F1 student should be coordinating with their university so that their SEVIS record, for example, is still active and all of the T's are crossed and I's dotted to make sure that there's minimal risk to traveling and coming back in.
Great. So let's get advice for those that are in F1 OPT status. And would your advice change, Miki, if the person has a different non-immigrant status? So they are not in F1. Would that have an impact on your advice with respect to travel if there's an H-1B change of status petition?
Yeah, absolutely. So it's really important for HR and the foreign national employee to know that only the F1 students are eligible for that scenario that I just talked about. Other categories like L1, E3, TN, and O1 would be considered to have abandoned their change of status request if they leave, if the H-1 petition is still pending with the USCIS. So that means they would have to get an H-1B visa stamp from a U.S. consulate outside of the U.S. before they can activate the H-1B status in the United States. And so triggers that additional step that we were talking about earlier. So it's important to plan ahead and make sure that expiration dates of the current status and timing of travel are all aligned.
Right. So that somebody is not stuck out of the United States. So that's important. So what about this situation where the company is filing the H-1B petition not for a change of status, but rather for consular notification?
Yeah, so in this kind of situation in general, we tell HR contacts that international travel doesn't impact the H-1 petition, but it's still really critical that the employee knows what's necessary to be able to return to the United States in their current status, and then how later to obtain H-1B status through the consulate process.
Okay. And if we're going to step away just for a second from the H-1B cap cases, what would your advice be with respect to travel, international travel, when there's an H-1B transfer, so a change of employer, or an H-1B extension of stay?
Yeah. So again, every situation is a little bit different, and it's really important to seek legal counsel before the travel happens. But in general, it's best that the foreign national employee not travel during the H-1B employer transfer once the H-1B petition has been filed with USCIS, and the same with an extension. But if international travel is absolutely necessary, we would consider the individual's current H-1B validity of the H-1 status and whether or not they have a valid visa stamp in their passport and how long the H-1 petition would be pending with USCIS. We would consider all of those factors to make sure that we're advising the HR professional and employee.
Right. So your advice is essentially every situation is different, and it's not that we're being nosy about someone's status, but it's really important to understand everything that's going on before advising. So I did very good. Okay. So our next topic, for people who don't currently have a valid H-1B visa stamp in their passport, how would you advise about what sponsored employees need to know before they attend their visa appointment at a U.S. consular post abroad?
Yeah, so I let our HR partners know that every situation might be different based on the consulate that they're applying for, not only their specific situation, but also the consular location, right? And their country of nationality and prior history with visa applications. There's also different wait times for an interview slot depending on the consular location. And the kinds of questions that consulate might focus on might be different. So we at WR, we want to be involved in these discussions so that we can help HR plan ahead.
Okay. So in some situations, we've been experiencing more and more lately that some foreign nationals may be exempt from the visa interview requirement. So can you elaborate a little bit more on that and help everybody understand what's going on?
Yeah, over the past few years, the State Department has expanded the interview waiver program and extended it. So for people who have a U.S. visa stamp issued that expired within the last 48 months, they can be exempted from the interview requirement and can instead use a mail-in option that sometimes people refer to as the Dropbox option. They can't mail in it from the United States. They have to be in their country of nationality or residence. But it is, beneficial to be exempt from the interview so that, they can get their visa stamps a little faster.
Great. And so even if someone is exempt from the visa interview requirement, can they still be called in for an interview?
Definitely. Absolutely. When we talk about this with HR contacts, we always let them know that even if somebody is exempt from the interview, essentially they meet the criteria, they can check off the boxes, but the consulate has absolute discretion to require someone to appear for an interview, even if they meet the requirements. So in most situations, the consulate will require an interview after they look at the documents provided by the foreign national in their mail-in packet. If their consular officer determines that there are questions that they need to ask further, or they may want to review additional information or documents.
Okay, great. So, pretty much any visa applicant can be subject to administrative processing, which can kind of prolong the process for the visa application. But can you explain to us a little bit more about what is administrative processing and how does it work?
Yeah, so administrative processing means that the consulate needs additional time and additional steps, additional checks in order to review the visa application and issue the stamp. It can be triggered by maybe the kinds of technologies that the individual might be working on in the US or their country of nationality. Sometimes it's because the applicant's name is similar to that of somebody else's on a security watch list. Sometimes it can be because the consular officer just wants a little bit more documentation, like a resume or employment letter. If that happens, the employee is given a notice that explains that their application is subject to administrative processing. The status of the visa application on the online platform might show pending or refused, and the consular officer will not provide any status updates. It's really essentially a waiting game, and it's sometimes hard because there's no way to know how long it'll take to complete.
Yeah, that is a tough process. What we were experiencing is it seems that there are some consulates that are more commonly issuing these administrative processing notices, more so than other consular posts. What trends have you been seeing, Miki?
Yeah, this is really critical for HR professionals to be aware of kind of the trends and what to look out for. China seems to be a common location for administrative processing right now. Also, Russian nationals applying at EU posts seems to be an uptick due to the geopolitical situation. Typically, the administrative processing can take an additional 3 weeks or so, but sometimes it can extend much longer, several months to sometimes even over a year. There's no way to predict. And it may mean that addressing how this will be handled, if the employee will be abroad for a while, will the company allow them to work remotely? How will the business plan for this long absence if they're not allowed to work remotely, because there are also tax implications that might come into play for the company too. So all of that, I think, is important to kind of have a contingency plan ahead of time before the employee leaves the United States. And one thing I'll just note is that, if the case has been in administrative processing for a long time, then, WR attorneys can explore with HR possible ways to get the case unstuck.
Great. Thanks, Miki. So with that being getting stuck in administrative processing and just the uncertainty of traveling abroad, we've recently seen the comeback of stateside visa renewals. So can you tell everybody a little bit about what is all the buzz with the stateside visa renewals?
Yeah, it's a pilot program that was launched in January of this year, and it just completed the initial pilot period in April. It's basically a program where the employee can mail in their passports to the State Department in DC to renew their existing visa stamp. It was previously available, but after 9/11, the program was terminated, citing security reasons, and they just brought it back as a pilot. And everybody was so excited. It was a very limited program, though, and not that many people qualified, but we hope that they will extend and expand the program in coming months. So stay tuned for more updates on this.
Yeah, that would be incredible if they bring it back for more visa types and other individuals. So thanks for giving us some more information about that, Miki. With that, we're going to wrap up our rapid fire about travel concerns during the summer travel plans. And if you don't already, please follow us on our LinkedIn page for WR Immigration, as well as on our individual profiles. We are also transcribing this live stream and post it to a weekly newsletter that you can subscribe to. The link to subscribe is in the comments. And with that, have a great week, everyone. And always great to chat with you, Miki.
Thanks so much, Kimberly.